This is not legal advice. That's a channel, and that's what this is. Please subscribe and like, and thank you. In the background, you might be hearing some noise. I'm listening to the ongoing Tesla trial, and I'm kind of reacting to it as it goes on, and I wanted to reference it a little bit that's going on. So when I'm not speaking, you might hear it in the background. Um, Let me tell you a little bit about it, and then again, when I'm not speaking, you might be able to hear it in the background. But I thought it was a little different because you could listen to it. And again, please subscribe. So it's Diaz versus Tesla. It's an ongoing regarding damages. So there was a prior trial. There was a large damage award. The judge reduced the damage award. The plaintiff, Mr. Diaz, who was, I think, an elevator operator at Fremont plant around 2016, he elected not to accept the revised reduced amount, which was still substantial in the millions, but the low millions, as opposed to like the $115 million jury award. And there's a retrial. So the retrials for damages started on Monday, jury trial. They will use basically the same evidence and same witnesses only and same exhibits theoretically that were in the first trial. However, I've been listening. I heard the testimony of, I think, a supervisor or somebody of a supervisory level who was involved in the elevator area. Thought he was reasonably credible. I've heard the judge, thought the judge sounds very sharp and very reasonable. He made a ruling that I thought was fair to Tesla. So that's kind of my first part. And again, he's the judge who had reduced the award in the first place. So it'll be interesting if the jury came back even with a large award, larger than what he reduced it in the last trial, whether he'd have to reduce it again. And then that would probably be subject to appeal. Um, the closing arguments will probably be Friday or Monday. Then the jury will decide on damages. And closing arguments, just to kind of clarify what a closing argument is, it's not fact, but what the attorneys will typically do is they'll use facts and pieces of evidence and then kind of create a story out of that and make an argument. So that's not for a jury to decide, but it kind of helps focus the jury on the facts and issues to decide. So there's a distinction in the when the judge gives the jurors the jury instructions, there'll be some instruction in there about that argument is not evidence, something along those lines. Also, just so you know that when there's a trial, before the trial starts, there's already an allocation of time. So the judge may have said that plaintiff has X number of hours to put on their case and defendant has X number of hours. So that is probably in play already. So there's probably an inherent time limitation. I know it was scheduled for 5 days, but sometimes that doesn't stick. The events are kind of stale from 2016, so I think whatever sympathy that exists for plaintiff may be lessened because of that delay and because people might be tight and in harder economic times, then maybe judgments might be lower. That's kind of the general kind of consensus.
Yes.
So,
And did he ever complain to you when you spoke to him about Mr.
so,
Martinez using any racial
so
slurs
as
or
I
racially harassing language
indicated,
related to this incident?
I'm listening to the trial in the background,
And so
and I think
the
that's
two
what you
incidents
may be
we've talked
hearing,
about involving
and the
racial incidents for Mr.
outcome
Diaz, they both
of
were to
the
you versus
trial,
residents
depending on
then
how it
and the voters,
goes.
incorrect? Yes.
If the award is small, then it'll discourage. If the award is big, then it might encourage, depending on what the judge does. So, what's relevant is at the same time in California, there's regulatory issues and litigation involving Tesla and California regulatory bodies. Uh, there's litigation involving the California Department of Employment and Fair Housing, who, over a period of time, I think pursued over 50 claims against Tesla related to workplace issues. and most, if not all, and when I mean most, I mean like close to all, if not all, of the claims were found to not be supported. And but it probably relies, probably all the claims in somehow, some fashion, were spurred or accelerated by the ruling in the Diaz case, which is the one that's being retried right now. At the same time, the California Civil Rights Department, which is the CRD, in February of 2022, filed an action against Tesla related again to workplace allegations of workplace harassment at the Fremont plant. Uh, Tesla countersued, basically saying that the department CRD didn't follow proper protocols. I think there was some kind of motion to dismiss, but in essence, that cross complaint is now in limbo. It's in limbo because in March, per a Tesla motion, it was determined by the court that the Department of CRD had not done, or had not shown proof they had done, an adequate investigation, and they, as a preliminary for them filing suit, they have to do a proper preliminary investigation. So the court has ordered them now to show that, and they might have to show protocols. They may not like that. It might prove to be embarrassing. It might release information they don't want to be released. So I think that in itself might be problematic to the agency and might chill or suppress future actions, justifiably if they're BS. And based upon the other ones I had referenced, there's a good shot that they might be BS, but I don't know. I haven't reviewed them factually. But I believe in part this also arises out of the Diaz case currently at issue, and the trial that, again,
You're
that
unclear about this
I'm
whole
listening
topic, aren't
to
you, sir?
in the background.
No,
Uh,
we're
so,
talking about things that happened many years ago. Okay,
and
when you gave testimony.
I believe, since they all arise out of the Diaz case, the outcome of the Diaz case will affect, I believe, how the regulatory bodies interact with Tesla in the future, and the fact that they have to show proof of the investigation might also do the same. And again, if they're justified, that's fine. But if they're BS, then they shouldn't be doing. They shouldn't be using state resources to provide a tax where they're not due. If they're justified, that's fine. But based on past history, there's a lot of wasted money, and taxpayers of California already pay enough tax. Anyway, so that gives you an update as to this current litigation and trial that's ongoing, that I'm, again, listening to in the background. And and that's it. Have a good day, and take care.